going to get started here in just about half a minute. Again, Nicole with TNT, Director of Training, and we are so grateful that you are spending your morning with us today. We've got an amazing presentation by Jim Bradbury, and we will be getting started here momentarily. Please note that everybody is currently on mute. We will be taking questions throughout the presentation in chat. Ask that you go ahead and drop any questions there. We'll make sure that you have access to the slideshow as well as a recording of the presentation after everything is finished this afternoon. And then again, drop your questions in chat and we will, there's like dust flying at my face, and we'll get started here in just a second. So Donna, we've got about 25 people on, and I'm gonna let you make the call if you're ready to go. And Jim, if you're ready to go, we've still got people joining. I can continue to admit people if you want to get started.
Excellent, let's do that. Good morning, everyone. I am Donna Lafitte with Texas National Title. We're so glad you're here with us today. We appreciate it very much. I just wanted to give a 2-minute brief commercial for Texas National Title. Our Farm and Ranch division, from the day we opened up business at Texas National Title, we created our Farm and Ranch division because we knew we needed experts in this field to handle these transactions for you. I have a lot of people ask me all the time, why should I use Texas National Title for my farm and ranch transactions? And I always tell people it's because of our people. And we have trained people that know what they're doing in farm and ranch. A farm and ranch transaction is typically a complicated transaction, and you need experts that know what they're doing. And we have people in our corporation, in our company, that are experts at farm and ranch transactions. And also our title examiners are expert at examining complicated large land transactions. So you are in good hands with Texas National Title. I also want to highlight the 2 ladies that are at the bottom of this little flyer we have for you right now. Leitra Zoll is our in-house legal counsel. And it's such a huge benefit to our farm and ranch clients to have that in-house counsel. She gets involved in our transactions as needed. She is there for you and your clients as needed. And she is absolutely brilliant at title and real estate as it pertains to closings. And so she's a huge benefit for us. And then next to her is Whitney Wright. Whitney Wright is one of our key farm and ranch closers within the company. She's closed numerous large land transactions for us, and she does a fabulous job, and you and your clients will love working with her. We also have Marie Farber, who is one of our farm and ranch closers, who's not pictured here, but she's fantastic, and we love her. You're going to work with experts when you give us a call. Want to let you know we can close transactions anywhere in the state of Texas, and that we encourage you to open title on your listings. When you get a farm and ranch listing, open title. Let us start title work. Let us find out what needs to be worked on. We can be handling any title issues while you are marketing the property for sale, so that when you have a contract, we are clear to close. So consider us for your next transaction. We'd love to work with you. Now, without any further ado, I'm going to turn this over. I'm going to tell you a little bit about Jim Bradbury, our speaker today. Jim, thank you. We're so grateful that you give us your time to do this for us. Jim Bradbury's practice focus is on land, environmental, water, and regulatory matters, including the imminent water policy issues facing rural Texas. Jim has a focus on the legal and policy issues facing Texas landowners and producers, working with statewide agricultural associations on legislative and regulatory matters. Jim Bradbury is an adjunct professor at Texas A&M Law School, teaching ag law, natural resources, and eminent domain policy, Jim has offices in Fort Worth and Austin. Jim, thank you for being with us today. We appreciate it so very much, and we're going to turn it over.
All right. Well, good morning. Thank you very much. And good to be with you all. Let me share screen here.
While Jim is getting that set up, I just wanted to let you know that we will have Jim's presentation that you're seeing today, the PowerPoint presentation, and then also recording, and that we'll be sending that out to everyone.
Okay, can you see the screen, Donna? Is that up?
Yes. Yep, we're good to go.
All right, thank you very much. All right, good morning, everybody. Happy to join you today and talk a little bit about fence law and run through some particulars on that. You may, fence law may seem like one of those things that's so obscure and so minor. How hard could it be, or how important could it be? But I will tell you, we've got a book I'll explain in a minute we did a few years ago. And since we did that book, I and Tiffany Lashmet, who is my co-author on this book, we probably get 2 fence law questions a week. So it's, happy to discuss this with you all. And as you have questions as I go through this, I would encourage you to throw them in the chat box and we'll stop and talk about them, because this is really a critical issue for landowners in Texas today. These issues are coming up, and I'll tell you, there's been a couple of recent Supreme Court cases, one just recently. So highly relevant stuff. On one second, fence law. Here's the book, and I'll give you a little description about it. The reason that Tiffany and I put this together a couple of years ago is we got so many questions, and we were getting questions from county sheriffs, county judges, landowners, other lawyers, and we realized there was absolutely no book or collection of fence law out there in Texas, which was really regrettable. So we put together this book called 5 Strands, and the best news about it, I will tell you, is it's absolutely free. It's online. AgriLife helped us put it together, and it's I like to say it's more of it's kind of a dashboard or glove box size book that you can print offline. Donna, I think, is going to send out a link to the book, so you're welcome to print that off, use it for yourself, distribute it to your customers, whatever you choose to do. All that we ask is we did not want to be paid for this at all. It was a service. But if you do, print a bunch of them in bulk for your customers, we just ask you to consider a donation to the FFA Foundation or 4-H Foundation. And, I think right now we're probably up to 25,000 copies of this thing being printed out there and handed out to Texans. So pull it down, and Donna will send you a link, but enjoy it. Okay. Fence law, before I get into the particulars of the law, as I like to say, there's no substitute for a cup of coffee. And, when you're a lawyer and you tell people something about the law, they feel very well armed, and then they run over to their neighbor or whoever it is they've been talking about building a new fence or having some issue and say, look, I know the law now, and I've got this book, and so I've got the upper hand in this discussion. The law is not any substitute for having a conversation, good relations with neighbor. So much of what I'm going to talk about deals with, two neighbors on opposite sides of a fence. And, the law is not the best first approach. If you're going to build a fence, you're having difficulty with a bull or animals getting from one pasture to another, take the time to go over and talk to that neighbor about it, particularly if you're going to be cutting brush or building a new fence. So consider that. And, if you all are representing some of the many Texans who are either moving here or buying a country place from the city and really don't know the rules of the road out there in the rural area, take a little extra time. I reinforce it with my clients who really don't know how how things work out in the rural areas is you got to talk to people, and you need to adjust your expectations of how things are going to work. Here's some broad categories I'm going to bounce through this morning. Liability for livestock on the roadway, which is probably the most important from a liability perspective. Then similar discussion for what happens if, you know, livestock gets on neighboring land, some animal or animals are somewhere they don't belong. Then a little bit about building and maintaining fences, and then lastly, fencing around oil and gas activities if you're in an area of production. Okay, let's talk a little bit about livestock on the roadway, and I really want to underscore the importance of this because I will tell you, I probably get 3 or 4 calls a year now from lawyers out in far-flung parts of Texas who are defending a ranch who had an animal get out on the highway, and there's an accident, a bad accident, and lawsuit gets filed. There are lawyers out there now who are indicating that they're specialists or claim to be specialists in livestock injuries, and they have experts on fence law. So there's a little bit of an industry that is developed on suing Texas landowners who've had livestock get out, and it can be a very significant liability, and it's super important to know what these rules are. So the way it works really is every county in Texas is in one category or another. Texas is open range as a base. That's the way we started, and it sounds really cool, but what open range means is the animals are free to graze, you know, wherever they choose to graze, and there is no obligation to fence them in. In an open range county, if you want to keep animals out of your property, you have an obligation to fence them out. There is the exact opposite of that, which is closed range. And again, this is county by county. We started out in Texas as all open range, but over time, various counties in Texas have voted to go closed range. I'll explain that process a little bit more in a minute, but understand now, whatever county you're in or whatever county you're working in, it's going to be one or the other. And in a closed range county, if you have animals, you have an obligation to fence them in. And why that matters is, of course, if an animal gets out there on the road, have an accident, first thing that's going to determine liability is, are you in an open or closed range county? If you're the landowner and you're in an open range county, then, but for a couple of exceptions, you're not going to be liable. But closed range, there is a good chance that you would face a lawsuit. So Texas sorting out, how do you know which county is which? I really wish I could point you to a list. The state of Texas does not have a list. Tiffany and I, this has been a knotty problem because, landowners and folks want to know, okay, what's my county? We're working on a list, but it's pretty difficult to determine some of these counties. My advice is, if you work in a couple of counties, call the county attorney, county clerk, county sheriff, somebody like that, maybe TSCRA special ranger in that county, and ask them. Chances are they know, but you're going to have to call somebody to find out, because that is extremely important. And something likewise, if you've got a customer buying a piece of property in that county and they have not been in that county before, you're going to want to highlight that for them. As I mentioned, Texas is open range as the base. So if a county has not elected to go closed range, then it is open range. And as you see, the Supreme Court there in 1999, phrased that as it's the right of every owner of animals in the state to allow them to run at large. You don't have to fence them in. 2 exceptions to that. The local stock laws, which is voting to go closed range, I've explained to you, but the other one is big. If your property borders on a U.S. or state highway, you must build a fence there. And that is true whether you're in an open range or closed range county. So if you've got property that borders the US or state highway, that landowner has to build a fence, and it's got to be a good fence to keep those animals out. Now, US and state highway does not include FM roads, does not include ranch roads, doesn't include, county roads. It is a US or state designated highway that rule applies for. But I always like to point out here is just because that's the rule and it's a highway, if you are on, one of these county roads that has become a de facto highway just due to population growth, you're not going to want to just bank on that. If there is a risk of a bad accident, you're going to want to have a good fence there, notwithstanding what that rule says. So those are the two major exceptions to, open range. A little bit more about the US and state highway. This is what the agriculture code says about that. The owner of horse, mule, donkey, etc., may not knowingly permit the animal to run at large on the right of the way of the highway. Now, focus just critically for a moment on that phrase, knowingly permit, and think about that. That's the legal test. So what does an owner, what do you have to prove to say, well, that owner knowingly permitted an animal to run at large? Some examples of situations that might fall into that category is if you have a weak portion of the fence, you've had animals get out before, the sheriff's had to come out there and collect your animals, put them back inside the fence. You have employees who chronically leave the gate open. Those are situations where you could become liable under that highway statute. We've had a recent Supreme Court case on this knowingly permit standard. I'll cover that in just a minute, but that last bullet point mentions, how often your animals are out, and furthermore, if you have an accident that happens, find yourself in the middle of a claim, one of the key questions they're going to ask is, how often have you looked at those fences? How often have you inspected them or had your employees inspected them? Those are things to really think about. Okay, so local stock laws, and when I'm talking about local stock laws, I'm talking about a vote to go closed range. That's what we call it as a local stock law. In those counties that have gone closed range, most of the votes were early on. Most of them we see are back in the 30s and the 40s. Sometimes counties voted countywide to go close range, and then there are some counties, just to make it even more confusing, certain counties, a precinct voted to go close range, but another precinct is open range. Those situations do happen in certain counties, but most of the counties that we encounter that have closed range, the county itself is close range. If you want to know, just how far back some of these things go, that's an example. That's from up in Hunt County. And so if you have to go determine, boy, is this county open or closed range, the county clerk is going to literally have to go back, pull those records, and you can tell by the script on that document how long ago it was prepared. But you'll see that's the record of the vote in Hunt County to go closed range. Okay, so now, let's say we're in a county and the clerk or the sheriff's told you, well, we're closed range. There are several other questions you're going to have to determine after you figure that out. You've got to find out which animal class does close range, because it's not just like a light switch that if you go closed range, then any and all animals are closed range. The votes could have been, say, we're going closed range based for beef animals, but not for horses. Sheep and goats may have been excluded from the vote. So literally, if somebody tells you, oh, we're closed range, you're going to need to ask some more questions to determine, hey, what animals does that closed range determination provide? Then the vote itself, you see number 3, this is determines what that legal standard is. Some of those votes, the language of the vote says a landowner shall not permit an animal to roam free. Some of them say an owner should not have knowingly permitted an animal to roam free. That's a big difference. I mean, proving that you knowingly permitted an animal is a high standard. That's very protective of the landowner, whereas a simple permit standard is a much lower threshold that a plaintiff, somebody seeking to recover and make you liable, would have to prove. Then finally, determine if the animal owner met the required obligations in the current situation. Those are the questions that in any legal action, people are going to be digging into to determine whether the landowner is liable for the accident. Little conundrum in the development of all these laws and stock laws across the state. We do not have a complete answer to the history, but there was a statute that was put in place in 1981. And if you know your counties in Texas, you can see that these counties are strung all over the state. They're not just in one part, but these counties by statute are prohibited from enacting a county-wide stock law. So in other words, they cannot go county-wide closed range. We don't know why. We've actually had the legislative research librarian dig and dig and dig to see if there's any clues back there in the legislative library, and there's really not. I mean, our best going hunch is these counties were the counties associated with some powerful committee chairmen at the time, and they did not want their counties going closed range. So those counties would have to get approval by the legislature to go closed range. So that is, in a nutshell, that's the law on open and closed range. And so just kind of keep that in your mind right now to say, okay, if I'm dealing with a customer in a county, I need to tell them, if you know, or tell them they need to find out if you're in open or closed range if they're going to run animals. As I mentioned, these things happen. And this case here is the Supreme Court case. It's very recent. You'll see it came out this year by the Texas Supreme Court. And, you know, we were all fairly surprised to see the Texas Supreme Court jumping into the middle of a fence law question, but they did. And these familiar scenario, but the owner had a bull who escaped out and wound up in the middle of the night on a highway, and bad accident. And so the question then became, hey, who's liable? Now, the interesting part about this is this county was closed range. They had voted to go closed range. And so animals are prohibited from being on the highway, but we have the highway statute, which I mentioned to you. So you have these two standards. The stock law that the county voters passed said a landowner shall not permit, but the highway standard says a landowner shall not knowingly permit. And this whole case turned around which standard is going to apply, the low standard of permit or the high standard of knowingly permit. It worked its way through the trial court, then it went to the Court of Appeals, and the Court of Appeals really kind of butchered the situation, for lack of a better phrase, and really got all tangled up in itself and confused this standard. So the case was headed to the Supreme Court, and a lot of ag interests became very concerned about it, because if the Supreme Court were to get the issue wrong, then you're going to have a piece of law on the books that's going to govern every landowner in Texas with some really bad laws. So as you'll see there in the second to last bullet point, Farm Bureau, cattle raisers, South Texas Property Rights Association in South Texas all got together to put together a friend of the court brief, which our firm prepared and submitted to the Supreme Court. And fortunately, the court, when they decided the case, they really got their hands around this issue, and they sided with the bull owner. the facts behind this is, it's one of those, the gate was clipped, had a little spring clip on the chain, but the spring had broken. The landowner was just, clipping it, but he didn't have that spring close on it. And then somehow this bull pushed against the gate enough that it popped, and he wound up in the road. But the court clarified that the knowingly permit, the high standard should apply, and therefore the landowner in that case was not liable. So it's a brand new piece of law out there that is, in essence, the law of the land in Texas on what the standard for liability is. Here's another, thing that just popped out of the blue. It's kind of an interesting story from far out in West Texas in Presidio County, if you know where that is. It's one of those counties I showed you a minute ago that is by statute cannot go close range. So it's big country out there, wide open, and fencing a property out there takes a fortune. So most properties are not fenced. Little dispute developed. One of these, you could make a movie out of it, but the county sheriff and the county attorney were absolutely smashing heads over a legal question, because there were animals that are getting into other people's property, but their property wasn't fenced. People were getting mad, calling the sheriff. The sheriff, under the stray laws, was coming out picking up these animals. And so literally, that county and community, there's not many people in it. So a big fight like that, half the county was on one side and half the county was on the other. The county attorney's position was, hey, this is an open range county, and therefore the stray laws, which is the law that allows a sheriff to come and pick up animals and impound them, should not apply because it's open range. The sheriff, on the other hand, very vocally and very publicly before the county commissioners out there, said, no, the county attorney is dead wrong. The stray laws apply in open range counties and closed range counties. And this got to be such an enormous tempest out there that they reached out to state rep and asked for attorney general opinion. And so that percolated its way through the attorney general's office in Austin, the Sheriff's Association, the Association of Counties, as well as TSCRA, all submitted legal authorities to the attorney general, and they came out also just recently with an opinion that said absolutely that the stray laws apply in open range and closed range counties. So even if you're in open range where animals can roam freely, the sheriff has the discretion to come out and pick those animals up and impound them. Okay, any questions now? Because I'm going to shift gears and talk a little bit about livestock on neighboring land.
If y'all have questions, feel free to drop those in chat. Or
right.
At this point, Jim, we don't have anything, so you're doing such a great job. Keep up the good work.
Good deal. I'm going to keep plowing then. Okay, so shifting gears. Now we're not talking about animals on the highway. Now we're talking about animals in a pasture where they don't belong or they're not wanted, which interestingly, that's how this book got started. Tiffany and I got a question from a county sheriff that was trying to settle a hot dispute in a county I won't name. But one landowner called and said, hey, I'm mad. I want you to come get these animals. My neighbor's animals are on my property. And a couple days later, he gets a call from the other neighbor, and he's complaining about the first neighbor's animals being. So sheriff called us, and of course, the reality of this situation is this was a 400-acre tract, and each of them had bought 200 acres, but both of them were so stubborn, they wouldn't put a fence in between the two properties. And so this was not really a question of whose animals belong who. It's just this is just two stubborn Texas landowners who they each had stock. And these, of course, how does an animal know where the property line is if there's not a fence? But ultimately, that was such a conundrum trying to help that sheriff through it. That's what encouraged us to put this book together. So, as you know already, if it comes back to the same question: am I in an open range or a closed range? Because if you're in an open range, the landowner that has the stock, or if you're in open range, the landowner has a responsibility to fence them out. If you don't want somebody else's cows in there chewing up your grass, you have to build that fence, not them. If you're going to build a fence, you know, there is a standard to build an adequate fence. It's in the ag code, and I won't go through it in detail, but you can see up there, and when you get the presentation later, you can look. But I mean, this is not a difficult standard to meet on modern fencing to have an adequate fence. You know, in a closed range, it goes exactly the opposite. The livestock owner has a duty to prohibit animals from running at large. So if you've got stock, you have to build fence around the perimeter of your property, and furthermore, it's got to be a not only an adequate fence, but more than an adequate fence, because in a closed range county, if your cows get across the fence, you know, that is your responsibility. It's going to be your cost. Where this can get very serious, I get questions about this, is you know, competing bulls. You've got one landowner in a closed range who's got a prize, you know, $40,000 bull, and then somebody else who's got a ranked bull from who knows where, and you know, that bull gets over there and severely injures the expensive bull or kills it. Those things happen, and then everybody's off to the courthouse, and then the question comes right back here to, is it open range, closed range, and how adequate was the fence?
Jim, we had a question on fencing.
Yeah.
So Betty was asking, you know, from the opposite end of the spectrum, on a lot and block type of neighborhood versus ranch, farm and ranch property, who owns the fence in a lot and block neighborhood?
Yeah, I'm going to get to a little bit when I talk about building fences, but let me cover it right now. I mean, we're talking about livestock here, but in terms of fence law and where you build fences, you know, it comes down to where it's built. There is no law that says, you know, your neighbor has to pay 50% of the fence. Hopefully you can work out an agreement to build it jointly, but you know, what we hope is that all fences are built right on the property line. But if you've looked at enough surveys and title opinions, you know that doesn't happen all the time. So if you're in the city, you know, if it's built right on the property line, then that fence belongs to both of those landowners. But if you are the one that builds it, you spend your money to hire the contractors to build that fence, then that fence becomes your personal property, if you are the one that spent the money. It gets a little more complicated if somebody builds it off the line or you build it inside, but I'll cover those details in a little bit more. But good question, because, you know, with respect to the legal aspects of fences, where they apply equally in the urban areas as they do in the rural areas.
Okay, one other question. Benjamin says he has a client with a pasture lease, and there's a third party in the lease contract. The third party is responsible for maintaining the fence next to a highway. So other than an overzealous attorney lumping everyone into a lawsuit, is there any precedent on owner liability?
There's not any case that's right solid on that. I mean, that's a very a good question, and sort of opens up a topic. I mean, a lot of folks have grass leases. You may be the landlord, you may be the tenant on those leases, and a lot of leases are done, you know, tragically, orally, just a handshake. There's no written document, or if there's written document, there's no discussion of who's responsible for fence maintenance. For all the reasons I discussed regarding highway liability, it is critical that any lease that is done regarding property make an allocation of responsibility. Either the owner says, I'm going to take the responsibility, or you say, look, tenant, you're leasing my place. You have the absolute legal responsibility to maintain that fence. Because if something happens, you're right. There is no guarantee, even if you've drafted it properly, that you won't get sucked in as an owner. But if you've got a good, well-crafted lease that says, no, sir, I leased it to this tenant, and the tenant undertook 100% of the responsibility for the condition and maintenance of that fence, then, you know, good chance you won't get sued at all. But if you do, then you're probably going to have a quick ticket out because you've got a contract that says, I, as the owner, did not have responsibility for that. So very, very important question. Okay. Keep flagging here. You know, finders keepers does not apply. This is talking about, you know, when that strange calf, cow, heifer, or whatever shows up on your property. You can't keep it just because you fed it for a few days. Always get a question on that. If you do have stray livestock on your property, this comes back to the estray law that I mentioned a minute ago. And what the process is you need to call the sheriff. You know, obviously, if you know it's your neighbor's cow, you just call your neighbor up and y'all figure it out. But if the animal is truly owner unknown or is unruly or otherwise, call the sheriff. And this statute that I point out there is what empowers the sheriff to come out and either himself with his deputies, or he has the ability to hire, you know, cowboys to come out and do it for him, to, you know, trailer up the animals, take them in and impound them. Try to find the owner. If they can't find the owner, they publish notice, and it can go all the way to the point of posting the animals for sale to cover the bill, because the sheriff is going to, you know, add up all his costs for feed and cowboys if he has to hire them, and anybody that, you know, comes in to claim the animal is going to have to pay that bill, or if it's sale, it's going to be deducted. But that is, other than two landowners agreeing how to do it between them, this is the legal process that we have for dealing with lost animals. You can't keep them, you can't barbecue them, you can't shoot them. I always get a question about this point here when we're in a live situation to say, well, what about exotics? What if, you know, what if I wake up one morning and there's an axis out there in my pasture? It's pretty much the same rule. This statute obviously doesn't mention exotics, but, you know, if you've got, you know, an adjacent landowner that runs a, you know, a high fence exotic operation, or it's, you know, half a mile away, that animal is still their property. And you don't have the ability to, you know, have a cookout by just claiming that animal. So,
Jim, we had another question related to exotics. Do you think that exotics will be classified as livestock in the future, and then fence laws would apply to them?
Yeah, great question. I mean, to be clear, right now, the statute, which is what this is statute law, doesn't apply to exotics. But that industry and people who have those in high fence operations has grown so much. We hear about these situations. I really do think we're headed in that direction. It's only a matter of time before, you know, a situation develops such that it's going to encourage a landowner or one of the exotic wildlife groups to submit a bill to the legislature to tack on exotic animals who are kept and maintained to be treated just the same as livestock are under those. But that's not the law today. But I still counsel landowners that you should treat it as just the same. Because if you have a bad situation, you know, some clever lawyer is going to say, well, yeah, it doesn't say exotics in the statute, but these same laws should apply by analogy, and a judge may go with that. But right now, that the statute doesn't say that. Okay, now we're in, you know, sort of the third phase of our discussion here, and let's go back to, this is probably where day-to-day you're going to have clients who get in a tangle with a neighbor, and that's over whether to build, you know, how to build a fence, how to go about building a fence, or replacing an old bad fence. As I mentioned to you, Texas doesn't have any statute that says your adjacent landowner's got to share in that fence cost. Believe it or not, there are some states that do have that, you know, where an adjacent landowner is on the hook for 50%. Seems normal, but that's not our law here. So if you go knock on your neighbor's door, talk to him about it, have that cup of coffee or a shot of whiskey, and you can't, convince them to come out of pocket, you're going to have to build that fence on your own. Now, if that's the case and you have to get out there, you got to buy the wire, the post, set the post, do the whole thing, and either do it yourself or pay somebody to do it, that fence then becomes your personal property. So in other words, when you sell your tract, that is your personal property that goes with the real property. Now, this raises the question of what happens if the fence is built inside the boundary line. You've got a neighbor that not only said, I won't share in the cost, but he said, you don't step a foot on my property while you're building that fence. If it's that kind of situation, you can't. It is trespass. There's no exception to trespass law for building a fence. So you will have to build it inside the boundary line. It likewise becomes the property of the builder. A little bit of a related point there is, likewise, unless you have permission, you can't go into your neighbor's property to remove trees, brush, shrubs from their side. Likewise, trees. You can cut overhanging limbs on that imaginary property line as it proceeds into the sky, but you can't cut trees on their side or lean over with a chainsaw on a pole and sort of, do a little extra trimming on their side. That is likewise trespass. These things happen. If you're replacing an old fence that's been there for a long time, then all kinds of trees and brush are in the exact boundary line. So it's going to be next to impossible to build a fence on the property line unless you clear a lot of brush. Where that tree trunk is determines the ownership. Of course, you're going to have that, those trees that are right exactly grown up on the boundary line. There, unless you have the full and complete trunk on your side, cutting that tree down, if you've got a nasty neighbor, you're going to put yourself at risk of some sort of trespass claim by taking that whole tree down. So, I've been doing this for 30 years, and you would be surprised at the very, very small matters that turn into a giant snowball of trouble. Little things like cutting a tree down, boy, people can get all balled up, and then they start chest pounding, and then everybody's off to the courthouse.
Jim, we have a question too, in terms of that, along the same trespassing lines. What if you're rebuilding a fence on the property line? At what point do you become considered trespassing?
Well, assuming you don't have an agreement with your neighbor, they haven't said, oh yeah, fine, I know you'll be on there, you just be careful and come on my property. If you've got a neighbor that has said, don't come on my property, or you don't have that permission, setting foot on the neighbor's property is a trespass, whether it's by you, the fence company, or otherwise. And it becomes only a question of how nasty does your neighbor want to be. But there is no sort of inherent right to say, well, I'm replacing a fence, so I need to just get a foot or so on your property to drive these T-posts down in there. It sounds silly, but I've got to tell you, that's technically what the law is. Now, most of us have neighbors that say, wow, if you're paying for the fence and the T-posts and everything else, have at it. But I like to say that every landowner in Texas has got a crazy neighbor. And if you think through it, you probably know who that is. But if you don't know who the crazy neighbor is, it could be you. But everybody's got one of those neighbors on one side of their property that is just cantankerous and doesn't seem to get along, and those are the ones chances are you're going to have a problem with. But you've got to clarify that trespass situation unless you're prepared to build the fence 100% from your side of the property. Because I said, you've got a nasty neighbor who said, no, stay off my property, so you're going to have to build that fence probably inside your property, a foot and a half, whatever it takes. So now you've got a fence inside your property boundary, and you've got some of your legal property that is outside that fence. And folks get concerned about adverse possession. I'm mentioning it here. It is really a very low risk that any landowner would lose a claim of adverse possession on this situation. But because people worry about it, I like to talk about it. And so here's a couple of tips. If you have to build inside your line, how you can protect yourself from any claim later is the easiest way is to, let your neighbor know by phone, hey, I'm going to build this fence a foot inside my property, and then follow that up with a little, can be handwritten letter that says, oh, hey, I built this fence. I finished it on, October 15, 2020, and built it a foot inside my property line, and I still intend to use that property outside my fence. Send it to them. Keep a copy. That's good enough. If you want to go the extra mile, or you have a lawyer that is your neighbor, you can prepare a document to go down and record it at the courthouse that says, I built this fence, it's my personal property, and it's a foot inside my boundary, but I still intend to use that foot on the outside of the fence, and you're protected there. Don't wring your hands a lot about this, but in the event that you have somebody that you're a little concerned about, or somebody may come and buy the property next to you, that's good enough to avoid any adverse possession. Rounding this out, one of the fencing around oil and gas operations, if you're out in West Texas, or down in the Eagle Ford or somewhere in Texas where you have current or historic oil and gas operations, there's no law that says an oil and gas company's got to place a fence around their tank batteries or their wellhead. The suggested approach that I and others make to landowners is get a little dialogue going, either with your landman or somebody at the company, to say, hey, you've got 2 facilities on my property. I've got livestock out here, and I know, I don't want my livestock injured, and you don't want any potential liability for injury to livestock. Would you consider building a 5-strand fence or something around your operation? And it's no guarantee. It's not a situation you can go into with a hammer and tell them, hey, go do this, because they're not going to respond well to that. But most times you can talk it through with an oil and gas company and get them to put up a fence around those operations. One other case is just brand new, and fence law case that, as you'll see, is not even a couple of weeks old, but just came out, and this was on Department of Corrections property. Animal got out, so you had livestock on State Department of Corrections property. Familiar scenario. The animals got out, 2 a.m., farm to market road. People hit the animals, very significant injuries, so lawsuit develops. The case went to the Court of Appeals. Don't know yet whether it's going to head to the Supreme Court, but the real question was one of sovereign immunity, because this is the state here that's the landowner and the livestock owner. And that's what the court ultimately made its ruling on sovereign immunity. And you'll see that they did talk about the fence law issues there, but my point in raising this, that these things can happen to anybody, even the Department of Corrections, and certainly sad and concerned about anybody that get hurt. But one lawyer I talked to about this was somewhat amused that the state agency responsible for keeping dangerous people away from all of us was unable to keep its animals inside the fence there. But I mean, these things happen. So here's another case that is working its way through the courts, and folks are going to be spending their time in the courthouse over an animal simply getting through the fence. So just some wrap-up points here for takeaway. Number one, and that's number one for a reason. Get to know your neighbor, whether you've got a fence law issue or not. If you've got clients coming out from the city, give them some clues sometime before or after the closing to say, hey, take some time, get to know your neighbors. If they don't bring you a pie, you take them a pie. You can take them a copy of this fence law book, but get some dialogue going. Do inspect and repair your fences. If you have a problem that turns into a legal problem, somebody's going to ask you that question. When was the last time that you checked your fences? Looking for livestock. If you run a lot of animals or your customers do, have them make a regular count to determine. Because if you have animals that have gotten out, everybody along that road is going to know it's your animals that are always out. And so if you get in litigation, those lawyers are going to start asking all your neighbors, and they're like, oh yeah, their animals have been out all the time. And then you're going to have a significant problem. Watch the trespass issue, and if you do have to build a fence off the boundary line, then document what you did by letter. Likewise, if you paid for it, send them a letter. Always call your neighbor before you send them a letter. Nobody wants to get a letter if you didn't call them ahead of time. You can just say, look, I'm calling to let you know a letter's coming just so we document this. No offense, and everything should be okay. And then last is the golden rule goes a long way. That's good life advice, but it's certainly good advice in fences because every piece of property has got neighbors on all sides of it, all of whom are going to have a different point of view. So it's important that you act in a way, or your customers act in a way that they'd expect to be treated. So that's all I've got on this. If there are questions or people want to talk about a particular topic, I'm happy to do it. But thank you all for having me.
It is our pleasure, sir. Absolutely. I've got about 3 questions at this point. Betty asked earlier on the counties. I know you said you're working on trying to do the list, but can you tell us open or closed on the nearest counties: Travis, Bastrop, Williamson, Hayes, and Burnett?
I wish I could, but I can't. If I went back and dug, I probably could, because I've given this presentation and spoken in those counties. And I know when I was in Burnett, I said, is this open or closed range? And I think the county agent said, blank. But I wouldn't want to, without checking, just spit that out. And that's another good person to call and ask, is if you've got a good county agent, call them and find out. But that is why we're trying to put together a list that we intend to, publish out there through the wires so everybody can have it. And beware, I will tell you, there's a few lists that people have tried to put together that are out there on the internet, and I don't think it was intentional, but I will tell you, we have looked at them and there are errors in those lists. And it's not that Tiffany and I are the smartest people in the state, but be very careful. Like everything, be very careful what you find on the internet. So no good list yet, but call the county agents or the county attorney's office and ask them.
Okay. If someone is replacing a fence and they then find out the fence is not on the property line, at that point, do they move the fence to the property line or leave it where it was initially?
Yeah, your call. My advice is, if you realize the fence you're replacing and you're taking it totally out, you're going to build a total new one, put it on the property line. Now, you may not want to pay for an accurate survey, and if you're standing out in the middle of a large pasture, which blade of grass is the property line is a little hard to figure out. But absolutely, if you know where that property line is, put it there. Getting into issues of title, familiar maybe to many of you, you may have had deals already where the surveyor is going to accept and say this fence goes wavy over here on this side, and it comes in and out of the property line. It's good for future transactions if you true that up to the property line.
All right, and then final question at this point: if a fence outlives the owner, does the agreement stay with the fence, or does that die with the owner if they've got an arrangement with their neighbor?
Yeah, I mean, if you, it would depend how you've documented it. If it's just an over the fence handshake deal, then, you know, you're not going to have anything. Let's say, you know, somebody from, I like to pick on Dallas, somebody from Dallas comes out and buys that property from your deceased neighbor you had a deal with. They're not going to be bound by that, which is, you know, always document things. So if you reach even a handshake deal, say, hey, your handshake's good enough for me, but why don't we, you know, just put together a little short document ourselves in the event that you sell your property or your kids take it on or something, you know, document that. And if it is documented, then that is something that would, you know, bind the future landowner that takes that.
All right, makes sense. Does anybody else have any questions that you want to drop in chat real quick before we wrap up and let Jim and you all get on with your day?
I do have a question. I noted in the chat that I've had a couple of landowners recently on sales. You know, they said, "Oh, well, the fence we put the fence inside the fence line because that's the way you're supposed to do it." And you know, sort of like that seems to be a pretty common myth, I guess, among landowners. So I wonder if you could speak to that.
Yeah. You know, like I said, finding the boundary line is hard to do. And certainly, you know, building a fence over on your neighbor's property is probably the worst scenario. You know, if you have three options, one, to find the boundary line, one is to build it knowingly inside, and the other is to possibly wind up with your fence on a neighbor's property. That's the worst scenario. So I still advise if you can determine it, from an existing or other survey, build it on the property line. I mean, that's where you want it. Now, you know, if you hire a fence contractor and he says, look, I don't want to be liable, right? I'm protecting myself here, so the safest thing to do is to build it inside your property line. You know, there's not a huge basis to argue with them, but you have that conundrum if you're building on your property line. You know, you have this little risk that somebody later is going to say, oh, you sacrificed that 6 inches, that 8 inches. I've seen that. And, you know, you can fix it in the way that I suggested, but, you know, to the extent that, you know, I would tell somebody what to do, I would say, find that property line, make sure your contractor either get them a survey or make sure they feel comfortable finding the pins to build that fence on. And because ultimately, if unless you're building it yourself, you're going to have a contractor out there doing it. And as an owner, you're a little bit at risk of the level of precision that your contractor is going to do. That's why these things happen, is somebody gets out there and it's a hot day and they sort of, you know, it's 6 inches off here and 6 inches off there, and then it shows up tight as a title problem later. So I still like the property line, but I agree it is, you know, it's hard to find out there in the field. But I think from a title perspective, which we're hosted here by a title company, so to avoid exceptions there by the surveyor and the title company, I'd be shooting for that property line rather than the you know, the myth and maybe practice of some that says I'm going to avoid liability and just put it inside your property.
All right, thank you, everyone. Any more questions? All right, well, Jim, thank you again. We're so appreciative of your time and being with us today. And just want to remind everyone that I will be sending out the PowerPoint presentation and the recorded version and Jim's contact information later today. So thank you again all for joining us. Thank you, Jim. Excellent.
You bet. Happy to join y'all. Y'all have a great day.
Thank you.
Okay, bye-bye.